Compulsory counterclaims, permissive counterclaims, and res judicata in debt lawsuits. This video is for people who are being sued by debt collectors and wondering whether they should file a counterclaim, or whether, on the other hand, they should wait and file a separate lawsuit. If they have a claim at all, of course. If this is a concern for you, you should also watch our videos on res judicata and statutes of limitation. They were intended to be listened to together. This video is brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. If you're being sued by a debt collector, you will sometimes have a choice whether or not to file a counterclaim, or whether you could file it as a separate lawsuit later. Part of the question is whether you will be able to do that at all, and that can be a question of res judicata. And then you have to watch the time also, the statutes of limitation. One main question of res judicata is whether you did or should have filed your claim as a counterclaim in the first place, rather than waiting and filing it as a new lawsuit. That question has presented courts with difficulties for a long time, and it's risky for you if you want to wait, although there can be good reasons for doing so. If you actually did file a lawsuit, that's clear. When the original case is over, so is your claim. The court must rule on your claim for the decision to be final, and so it's gone. But the complication comes when you don't file it as a counterclaim. Then the question is whether you should have. If you should have, it's called a compulsory counterclaim. What constitutes a compulsory counterclaim is determined by state law. The way you find that out is by researching compulsory counterclaims with your state in mind. Here's the broad general rule regarding compulsory counterclaims. If a claim is so closely related to the lawsuit that it's already been filed, and if the court has jurisdiction to hear it, then you got to file your claim against the plaintiff as a counterclaim. You can't wait. Most states seem to apply at least one or both of these two tests to decide whether it's too closely related for you to be able to put it off. There's the evidence approach or the transactional approach. We won't go into either of these in depth here, but in broad terms, the evidence approach asks whether the same evidence would apply to both the claim and the possible counterclaim. And of course, we're not talking about all the same evidence, but there's a question of how much overlap there would be. So, for example, if a guy was suing you for a breach of contract and you were suing him for fraud, there would be a tremendous amount of overlap in those two things, and the evidence would basically all be, the same for both sides. The transactional approach asks whether the claim and the counterclaim were part of the same general transaction or deal. So again, in the fraud context, that would be pretty obvious, right? They're the same deal. The underlying question is whether it's hugely wasteful to litigate the issues more than once, versus the rights of plaintiffs to choose the time and place to bring their claims. They shouldn't be rushed by a potential defendant into bringing a lawsuit they're not ready to do. These days, the courts are really eager to save their own time, so that's an issue. And then the other thing is that if you have different lawsuits, there's always a possibility of getting inconsistent judgments, and that's embarrassing to the courts. So if your claim is closely related to their claim, you got to watch out. In addition to these relational rules, some states have a flat-out rule that may require you to file as a counterclaim any previously existing claim that you have, or else lose that. That is to say, you've got to bring it as a counterclaim, or you lose the right to bring it as a lawsuit. This is rarely an issue for debt cases, though, against debt collectors. It's more possible against original creditors, though, where you have more of a relationship. But what about FDCPA claims? Your claim under the Fair Debt Collection Practices Act, is that compulsory? They are certainly permissible or allowed, but as far as I know, no courts treat them as compulsory. Still, you got to check your state law. You got to do the research to find out. What if you raise an FDCPA defense? Let's say the debt collector's obligation to verify before taking further actions to collect the debt. And then later you try to bring it as a separate lawsuit, and a lawsuit under suing them for violations of the FDCPA. So as you know, when you appropriately dispute a debt and request verification, the debt collector has to verify it before it takes action, including, in most jurisdictions anyway, filing a lawsuit. If they do file a lawsuit, you can use that as a defense. You can ask the court to dismiss the case. But it's also a violation of the FDCPA, and so you could bring it as a separate lawsuit as well. This can be borderline sometimes, but the only cases I've seen have allowed it. Remember that the FDCPA is not your only source of rights against a debt collector. Your other claims may be more closely related to the initial transaction and could be barred, and they could also be barred under that previously existing claim thing that some states have. So you have to be careful and consider your options carefully. This issue arose for one of our members. The debt collector seemed ready to dismiss the claim against our member, and our member wanted to know whether it made sense to add a counterclaim. We thought it might make sense to wait, as filing a counterclaim would likely slow down the dismissal. We didn't think res judicata would kill the new suit, so it was a question of strategy. This video, I remind you, is intended to be watched in conjunction with our videos on res judicata and statutes of limitation if you're seriously considering not filing a possible counterclaim in hopes of later filing a lawsuit of your own. It is a riskier proposition to wait and file later, but sometimes it does make sense to do. Give them heck. Defend yourself from the debt collectors and don't let them rip you off. Please like this video, comment, and share it with others, as these things help other people find our materials. YourLegalLegUp.com